linking refugee and environmental law. We've got 4 speakers. I'll introduce you sort of as we go through. And so first is Jolanda van de Vliet from Leiden University, who's going to talk about climate refugees and legal mapping exercise.
Sure. Thank you. Thank you very much for organizing this really nice workshop. I'm delighted to be here, and I will be building upon the presentation we just saw. It's a bit more abstract than the last one, but it's still early, so I hope you can all manage. So I started out with today's ambition, and I thought it was very interesting to see that we're looking at a fundamental gap in academic literature and policy making. And we try to close that gap through environmental law and refugee law. What's interesting is that we're looking at a gap in policy making. And I think it's a really good thing to do just that, because if we look at the policy papers and academic literature, we often see a rights, a responsibility, or a security perspective. And it's important to look at those perspectives because they carry different sets of assumptions and logical outcomes. And these outcomes are connected to the political views. These outcomes are regulated by different legal regimes, so it depends on the political course you take which legal solution seems logical. Hopefully it makes more sense in a bit. If we look at a rights-based approach, this is an approach we heard the professor before. It's generally accepted. It has been applied by regional human rights courts. There we see that environmental degradation causes infractions of human rights, and it addresses environmentally forced migration through the impact that it has on people. So sometimes, like with the NANSE initiative, it's limited to a disaster perspective, so we only look at people that have their rights inflicted by disaster. But what's important to keep in mind is that it assumes that the migration is forced. And this is really important because it's hardly ever discussed whether this is the case. From a legal point of view, it's very hard to prove that the migration is forced. And it's not a very relevant question from a legal point of view if you look at it from a human rights perspective. As we look at vulnerable people and we look at which rights are harmed by environmental degradation, it is not very interesting if the migration was forced or if it was voluntary. It's just a matter of protection. So that's an important point. It's very interesting if you use this approach that we look directly at the people who are impacted. It's very clear to see what's happening to their lives, to their properties, to their education. It gives a really nice image. But it also gives a limited scope because we are looking through the lens of a rights-based approach at human rights law. Sometimes we look at it through a migration or refugee scope, but then all of a sudden the assumption that the migration was voluntary creates a problem. Because as soon as you want to cross the border, if you want to apply for refugee status, the movement has to be forced. So the assumptions in the approaches are different, are very important from a legal perspective. So we also have another type of approach. And I'm not sure how many of you are familiar with this approach, but it's quite a hot topic in the Netherlands. It's a security approach. And this is looking much more at environmental degradation and forced migration as a threat multiplier. So now it's looking much more not at vulnerable people, but at state interest. It's the best interest of Western states to do something now in order to prevent large-scale unrest later on. It's not just the state interest, it's stressed very much that it's also a human security perspective, so they also look at the people on the ground, so then you see that it gets mixed a bit with the human rights approach. And the assumption here is quite different. Where the human rights-based approach consider the movement as forced, this approach is considering the movement to be voluntary. Western states will stress all the time that migration is voluntary. They don't want masses of floods of refugees crossing their own borders, so they stress the non-voluntary nature of the flight. It's the same group of people, the exact same situation, but they have a different assumption. So we can see two different movements here. Either we look at solutions for the problem that are just talking about border protection, a really hot topic in Europe right now, or they look at solutions which might be more interesting, such as, for example, development aid, humanitarian assistance, or other ways of aid, or even diplomatic measures, everything in order to keep the peace and to keep Western state as comfortable as possible. So different interest also opens up different tools that might be very welcome in solving this problem. From a legal perspective, this will focus mainly on migration law and human rights law, but it will also look at, for example, bilateral or multilateral conventions in order to coordinate the use of shrinking resources or an abundance of resources. So everything to keep the peace. Now there's one more approach I want to discuss with you guys, which is the responsibility approach. And this approach looks at the polluters. So no longer vulnerable people or states, but polluters. Another different perspective. And they look at the obligation for polluters to assist the countries that will suffer most and look for accountability. Now, this is difficult because it assumes quite a lot. It assumes that the countries of the north cause the pollution, which causes climate change, which causes migration, and that we can construct a causal relationship between all these steps. Now, from a political point of view, this might seem easy. From a legal point of view, this is not. So if we look at the solutions, they try to hold polluters accountable and to prevent environmental degradation and climate change and compensate victims. From a legal discipline, we look at environmental law and international law on state responsibility mainly. So to put it in a picture, it might make a bit more sense. If we have these different approaches, we can see that it addresses different parties. It is governed by different types of law, but it also has a lot of implications. Because if we look at a time frame, for example, if we look at the rights-based approach, the protection starts after the infraction took place. So you're protected after the human rights violation. So it does not focus on prevention. It does not focus on adaptation or mitigation because the protection starts much later. A security approach, on the other hand, can open up to prevention as well, as long as you can convince states that it's in their best interest. The responsibility approach, when it's governed by environmental law, the environmental law is mainly focusing on prevention. So it opens up a different time frame. It also opens up different types of protection. For example, yes, I'll wrap that. Yeah. If you look at a rights-based approach, this is a very interesting approach for slow onset disasters. Because, as we all know, slow onset disasters is very difficult to prove that the movement is forced and that it's caused by environmental degradation. Now, a rights-based approach doesn't care because they only focus at the human rights. For a security approach, slow onset disasters simply do not apply for the Refugee Convention, so it's really hard in that context. From a responsibility approach, slow onset disasters are very difficult because you have to prove causality, which from a legal point of view is really hard. But it does apply very well to sudden onset disasters because it's very clear what's happening and it's happening in a quick pace. So to be aware of the different approaches opens up new ways of protection. I will race through the rest. What should we do with all this information? We should look at the framing. If we want to put the topic on the agendas of all the important players, we have to be well aware of how we frame the topic. We have to keep in mind that rules should be interpreted in the light of their aim and character. I'm saying this because a lot of people propose to open up the Refugee Convention, and I couldn't disagree more with that. But if we frame everything in a better way, and if we are aware that even as legal scholars we have to frame it in a political way to find access to protection, then we can also try to play around with those different frames, try to impose new protection regimes by opening up other frames. What should we do? We should be aware of the strong points of each and every approach, and we should be aware of the weaknesses and try to pick that approach that best serves the type and time frame of the movement that we see. That's my main point. That's why I call my presentation, it's a legal mapping exercise. There is no one-size-fits-all solution to this problem. It's so diverse that we really have to play with the legal regime. I don't think there will be an all-considering legal protection framework anywhere soon. So we just have to do some kind of cherry picking, but be aware that we work for politicians. So keeping in mind their frame, spark their interest, and make sure that we protect them the best way we can. I think I'll wrap it up here. I can talk for hours.
Thank you very much. Okay, next we have Jenny Poon from Western University, and the title is Drawing Upon International Refugee Law, Addressing Climate Change Refugees Through Preventative Action.
Thank you for inviting me today to this workshop. To begin, I would like to set some context. And I would like to highlight the example of displacement of Pacific small islands. The Pacific Islands are a group of 11 Pacific Island countries, such as Fiji, Marshall Islands, and Papua New Guinea, which are the most vulnerable to climate change displacement. These islands face a serious threat to their social and political stability due to constant rise in sea levels. Those who live on these Pacific Islands will be forced to continue to relocate internally, and if possible, across borders as a result of climate change displacement. In fact, based on 2009 estimates, a maximum of 1.7 million people are projected to be affected by climate change displacement by 2050 from Pacific Islands alone. So by this estimate, climate change, Pacific Island inhabitants will become climate change displaced persons by 2050. So to set up a roadmap for my presentation, I will begin with key definitions, including reparation under international environmental law and the principle of non-refoulement under international refugee law. Then I will talk about the importance of addressing climate refugees and the current protection gap in the law. And I will provide some recommendations for future. So to begin with definitions, climate change is defined as a change of climate which is attributable directly or indirectly to human activity that alters the composition of the global atmosphere, and which is in addition to natural climate variability observed over comparable time periods. It includes sea level rise, sea and surface temperature increases, extreme weather events, and increases in sea temperature. Next, I will be talking about the definition of climate refugees or climate change displaced persons. So is the term climate refugees accurate in depicting those who are fleeing from climate change effects? According to Jay McAdam, a top international refugee law expert, the term climate refugee is erroneous because the environment is a trigger but not a cause of migration decisions. I suggest that climate change displaced persons may be a more accurate descriptor. Climate change displaced persons are groups of people whose habitual homes have or will become temporarily or permanently uninhabitable as a consequence of a climate change event. The displacement may be temporary or permanent and may take place within a state or across its borders. Next, I would be giving the definition of environmental refugees. Environmental refugees are persons forced to migrate due to impacts of environmental deterioration, and these people are termed environmental refugees. These environmental refugees face temporary displacement due to temporary environmental stress, permanent displacement due to permanent environmental change, temporary or permanent displacement due to progressive degradation of environmental resources, or temporary or permanent displacement due to deforestation, rising sea levels, land degradation, and water scarcity. The rising number of global environmental refugees and the failure of the Refugee Convention to recognize and protect the rights of these individuals is a gap in the law that must be addressed. And for the purpose of this presentation, the term climate change displaced persons will be used to encompass those who are displaced by climate change and environmental refugees. Now I'll turn to the principle of reparation under international environmental law. The principle of reparation is a general principle of international law and is codified in Articles on State Responsibility, which states that a state is liable if it performs illegal acts and is held accountable for adverse consequences on legal activities. In the international environmental law context, there is an obligation to make reparations where there has been a breach of engagement of an obligation, such as causing environmental damage. Environmental damage refers to damage to the environment, which has been defined in treaties to include 4 possible elements: water and climatic factors, material assets, landscape and environmental amenity, and interrelationship between the above factors. Next, I would like to talk about the principle of non-refoulement under international refugee law. Non-refoulement is a central tenet in international refugee law. It is the right of the asylum claimant or refugee not to be sent back to his or her country of origin to face persecution. In other words, the state cannot send a person back to his or her home country if he or she will be tortured or otherwise face a serious human rights violation. This principle is an obligation that binds all states regardless of whether they're state parties to the Refugee Convention. Under this principle, the asylum claimant and refugee are protected as long as they demonstrate a well-founded fear of persecution, regardless of whether they have been formally recognized as a refugee. Having set out these various definitions, I argue that they are all interrelated. Traditionally, international environmental law is focused on reparations. International refugee law, on the other hand, focuses on the protection of vulnerable populations, such as asylum claimants, refugee, internally displaced persons, and stateless persons from future harm. Therefore, I argue that international environmental law can borrow from international refugee law principle of non-formal as a protection mechanism to focus on the protection of future harm rather than on reparation after harm has already occurred. And I'll come back to this important point later on in my talk. Now I would like to talk about the importance of addressing climate refugees. There is a trend of growing number of climate change displaced persons worldwide. In fact, 36 million people were newly displaced in 2008 due to sudden onset of natural disasters. The guiding principles on internal displacement, which is established in 1998, recognizes the right of those internally displaced, such as the right not to be arbitrarily displaced from one's home as a result of disasters. The Refugee Convention, on the other hand, protects those who have been left homeless or fleeing after World War II. However, the Refugee Convention, as it is currently worded, does not recognize climate change displaced persons as refugees within the Convention definition. Since there is a requirement that refugees have a well-founded fear of persecution and environmental degradation does not qualify as a form of persecution. The guiding principles also do not protect those fleeing climate change in their country by traveling to a different country. The guiding principles only protect individuals who are internally displaced within their own country. Climate change displaced persons, therefore, who are displaced across international borders are not afforded protection as a result. Now I'll turn back to the important point of addressing climate change displaced persons by drawing upon the protection mechanism of international refugee law as demonstrated in the principle of non-refoulement. The principle of non-refoulement as a principle of harm prevention may be applied in the context of climate change in order to address the protection gap faced by climate change displaced persons in a number of ways. First, non-refoulement is forward-looking in that it prevents harm from occurring instead of finding solutions after harm has occurred. Second, non-refoulement prevents harm where there is a high likelihood of harm occurring in the form of persecution instead of preventing harm where there is absolute evidence, which is a higher threshold of harm occurring. Third, non-refoulement prevents several types of harm from occurring, namely human rights violations in the form of persecution such as death penalty, torture, or other cruel, inhuman, or degrading treatment or punishment. Similarly, I suggest that the principle of non-refoulement may provide a basis for international environmental law to establish a protection mechanism to prevent the adverse effects of climate change from harming climate change displaced persons. First, this protection norm, similar to non-refoulement, must be forward-looking in order to prevent the effects of climate change from adversely impacting the lives of climate change displaced persons. Second, this protection norm should prevent harm where there is a high likelihood of harm resulting from climate change effects, rather than preventing harm when there is absolute evidence of harm occurring. Third, this protection norm should prevent a variety of harm from adversely impacting climate change displaced persons to their detriment, such as the prevention of human rights violation as a result of governments not having proper evacuation procedures in place and declared states of emergency. In the last part of my presentation, I would like to suggest a few recommendations to address the protection gap for climate change displaced persons. First is recognizing environmental refugees or climate change displaced persons as members of a particular social group within the Refugee Convention. So the Refugee Convention defines a refugee as someone who is fleeing from persecution on account of his or her race, religion, nationality, membership of a particular social group, or political opinion. And it has been suggested by some academics that climate change displaced persons satisfy the common characteristic ground of membership of a particular social group by their lack of ability to protect the environment. However, one criticism of this approach is that climate change is not necessarily persecutory for climate change displaced persons to be recognized as refugees. And then the next recommendation I have for addressing climate change displaced persons is by renegotiating a new treaty. I argue that the Refugee Convention needs to be updated in accordance with new developments, such as the rights that are already recognized under the guiding principles, in order to maintain its relevance to current global realities. However, this approach is not without criticism, such as the difficulty of defining what events would constitute climate change sufficient to warrant protection. Another criticism is the problem of determining what protections are specifically accorded to climate change displaced persons that do not overlap with existing protection mechanisms found in international human rights law instruments and the Refugee Convention. Another criticism may be that a broad definition of climate change displaced persons may create a floodgates argument. And to conclude, I would like to say that, as demonstrated, there remains a protection gap for climate change displaced persons fleeing from effects of climate change. I've recommended that the international environmental law to borrow from international refugee law principle of non-refoulement to establish a protection mechanism to prevent harm from occurring to climate change displaced persons, rather than to focus on traditional reparation after harm has occurred. International law is split into two silos, namely international environmental law and international refugee law. The former has no individualized response to effects of climate change, while the latter has an individualized response, such as allowing individual examination of asylum claims. I suggest that non-refoulement bridges this silo, which should protect climate change displaced persons from being sent back to their countries of origin to face the adverse effects of climate change, such as the sinking island. Thank you.
Thank you very much. And next we have Petya Pishmisheva from the UNFCCC, who is talking about migration, displacement and human mobility in the context of the Climate Change Convention.
Thank you very much, Alexandra, and thank you very much for organizing this workshop and inviting us. I don't have any slides, but I do hope that if you have any questions, you may ask them throughout my talk, and also I hope we'll have enough time to answer questions. I would like to outline what are the current processes and institutional arrangements under the Climate Change Convention with respect to human mobility, migration, and displacement. And as Professor Preventative referred to the Cancun adaptation framework, I would like to start with this reference. It was back in 2010 when the Conference of the Parties to the Convention, and just open the bracket by saying Conference of the Parties, I would like to note these are 196 parties which have adopted the Climate Change Convention. They recognize that there is a need to enhance action and to encourage all parties to undertake measures to address or to enhance understanding, cooperation, and coordination with regard to climate change-induced migration at the national, regional, and international level. At the same year, there was a work program that was established to address loss and damage associated with climate change impacts. This work program placed the knowledge base and did quite a lot of technical work in the form of technical papers and expert meetings, which was further developed with another decision by the Conference of the Parties 2 years later in 2012 in the Doha COP, which further recognized that there is a need to enhance the understanding in respect of how climate change impacts are affecting patterns of migration, displacement, and human mobility. And with this in mind, then 2013 came when in Warsaw the parties decided to establish a Warsaw International Mechanism to address loss and damage associated with climate change impacts. These impacts are related to both extreme events and slow onset events in developing countries that are most vulnerable and affected by the adverse effects of climate change. The Warsaw mechanism is therefore quite a new mechanism under the convention, and it has three functions which I will not go into details but just very broadly outline as enhancing the understanding and knowledge, enhancing the cooperation, coordination, dialogue, synergies, and by this the parties mean not only coordination between the bodies under the convention, but also with different agencies, bodies, UN agencies, NGOs, up to private sector outside of the convention. And the first function is action and support, including finance, technology, and capacity building. The mechanism itself and these functions, they are guided by an executive committee, and maybe this is what we are now all aware and the work of this executive committee. Just to put a little bit of face to this committee, which may be a bit abstract, it is composed of 20 members with equal representation of developing and developed countries. The executive committee is currently implementing its initial 2-year work plan, which was adopted in 2014 in Lima. Therefore, the time span for its implementation was last year and this year. The work plan itself deals with a number of topics associated with the adverse effects of climate change. It has 9 action areas, and one of those action areas is related to displacement, migration, and human mobility. Maybe I will tell you a little bit more of what the executive committee has done last year and this year in respect of their work on migration and displacement. Earlier this year, the executive committee issued a call for submissions of information, of scientific information related to both cross-border and internal displacement, and I think maybe this call has reached you one way or another. I know we have had some submissions as well. There were more than 70 submissions from 30 experts and organizations submitted. It was very rich, and these submissions, the follow-up would be that they will inform a technical meeting on displacement, migration, and human mobility. This technical meeting will take place later this month already, and it is organized by the International Organization for Migration. And my colleague Mariam may give you more details, therefore I won't focus too much on it, but this is the immediate work that is progressing very recently. Let me also draw upon another action area that is very closely related to the topic, and which I didn't hear in the presentation so far, but maybe this will come up. It's on non-economic losses. Non-economic losses are those which are very difficult, if not impossible, to assign monetary value. These are losses such as loss of life, a loss of health, loss of indigenous knowledge, or cultural heritage, biodiversity. So there are a range of these, and as you can see from the nature of those losses, they are closely linked to displacement and the situation that displaced people are facing. In its last meeting, which took place in April this year, the executive committee adopted terms of reference for an expert group. This expert group will consist of 4 EXCO members, but also 8 experts from different organizations, and they will also tackle the issue of displacement in the context of non-economic losses. So this is also another area of work where this would come up. And of course, you are aware of the 2015 Paris Agreement and the mandate given by the Conference of the Parties to the Executive Committee to establish a task force. This task force is to provide recommendations for integrated approaches to avert, minimize, and address displacement related to the adverse effects of climate change. The task force also needs to draw upon and work and involve other bodies under the convention, but also relevant organizations and experts outside of the convention. In terms of the stage of work of the executive committee in this task force, as was the mandate by the Paris Agreement, the EXCOM started to consider this task at its first meeting this year, which took place in February, and they continued work in their third meeting in April, and they are still continuing intersessional work. The result of this will be presented during the fourth meeting of the executive committee, which will take place later this year in end of September. Yes, this is the status of work. As you can see, quite a lot has been done throughout this year, given that the work of the executive committee started from its first meeting last year when we met in September. And there are quite a few developments in this sphere, and I'm very much looking forward to the rest of the presentation and to the program. It seems a very rich and it's also a learning experience for us to see this different point of view. So do please ask any questions. I am aware that our process could be sometimes a little bit complex to understand in terms of how it works, but I will be happy if I could contribute to explain this better. So thank you very much.